Hello friends, today we'll discuss the revision of section 148 of the Income Tax Act 1961. As you know, there is a confusion at present and lot of litigation has already been started whether the department can issue a notice under section 148 under the old regime after 31st March 2021. The Finance Act 2021, after being passed by the Parliament, and it also get the consent of the President on 28th March 2021, and that has become the final law which was effective from 1st April 2021. Of this Finance Act 21 has substituted the provisions relating to the reassessment, and a new set of reassessment proceedings have been introduced with effect from 1st April 2021. After the insertion of this act, the old provision relating to the reassessments as section 148 do not survive. अब इसमें क्या हुआ है, इसमें लिटिगेशन शुरू हो गया. अब गवर्नमेंट ने ड्यू टू कोविड आया था तो उन्होंने ये कहा था भी कुछ जो प्रोविजन है विद इन लिमिटेशंस दैट शुड बी extended, and for the purpose they have taken the taxation and other laws, relaxation and amendment of certain provisions Act 2020. इस एक्ट को इन्होंने लिया था which were deemed to have come into force with effect from 31st March 2020. इसका एक सेक्शन है, सब सेक्शन 1 और सेक्शन 3 है. उसके बाद इन्होंने एक नोटिफिकेशन इशू किया था, नोटिफिकेशन नंबर 20/2021 डेटेड 31st मार्च 2021. उस नोटिफिकेशन में इन्होंने कहा था कि वेयर द स्पेसिफाइड एक्ट इज द इनकम टैक्स एक्ट 1961, द कंप्लीशन ऑफ एनी एक्शन रेफर्ड टू इन क्लोज A of subsection 1 of section 3 of the Act relates to passing of an order under subsection 13 of section 144C or issue of notice under section 148 as per time limit specified in section 149 or sanction under section 151 of the Income Tax Act. They said in clause 1, the 31st day of March 2021 shall be the end date of the period during which the time limit specified in or prescribed or notified under the Income Tax Act falls for the completion of this action. And they have said the 30th April of 2021 shall be the end date to which the time limit for the completion of such action shall stand extended. इसका explanation number 1 क्या कहता है कि for the removal of doubts, it is hereby clarified that for the purpose of issue of a notice under section 148 as per time limit specified in section 149 or sanction under section 151 of the Income Tax Act, under this subclause the provision of section 148 and section 149 and section 151 of the Income Tax Act, as the case may be, as they stood as on 31st day of March 2021 before the commencement of the Finance Act 2021 shall apply. अब इसको हम इस तरह समझते हैं. अब जो नोटिफिकेशन डिपार्टमेंट ने इशू किया है 148 के अंदर, इसका वायस जो है, जो अभी मैंने आपको टैक्सेशन एंड अदर लॉ, रिलैक्सेशन एंड अमेंडमेंट ऑफ सर्टेन प्रोविजन एक्ट 2020 बताया, इसकी क्लॉज को जो है सब क्लॉज 1 of section 3 has been challenged in the Bombay High Court. And recently एक डिसीजन है साहिल इंटरनेशनल वर्सेस असिस्टेंट कमिश्नर ऑफ इनकम टैक्स सर्कल 19(3) and others by the Bombay High Court, जहाँ पर उन्होंने पटिशन ने चैलेंज किया है नोटिस जो इशू है 148 का, जो कि 31 मार्च 2021 के बाद इशू हुआ है। उन्होंने ये कहा है कि भाई गवर्नमेंट हैज़ नो पावर टू extend the act and the limitation bypassing of this special provision. अब पिटिशनर ने बॉम्बे हाई कोर्ट के अंदर साहिल इंटरनेशनल केस के अंदर उन्होंने कहा है कि जो respondent purport to invoke repealed provision of section 148 of the Income Tax Act without following provision of amended act, issuing notice dated 7 जून 2021। तो इसी एक्सप्लेनेशंस के अंदर उन्होंने कहा है कि जो वैलिडिटी है और एक्सप्लेनेशन ए ऑफ नोटिफिकेशन 2021 अंडर द टैक्सेशन एंड other laws, relaxation and amendment of certain provision Act 2021 has been challenged in this court, and court has issued a notice dated 5 July 2020 in the case of Tata Communication Transformation Services Limited versus Assistant Commissioner of Income Tax, Bombay। और साइल के अंदर भी जब नोटिस उन्होंने इशू किया है तो उसको भी उन्होंने स्टे कर दिया है और 2 अगस्त 2021 के लिए फर्दर हियरिंग के लिए ये मैटर को रखा है। एंड ऑनरेबल दिल्ली हाई कोर्ट आल्सो इन द केस ऑफ मुद्रा फाइनेंस लिमिटेड, अंसल कलर्स इंजीनियर्स एंड अंसल लैंडमार्क टाउनशिप प्राइवेट लिमिटेड के केस के अंदर भी ये इशू आया और ऑनरेबल दिल्ली हाई कोर्ट आल्सो हैज एडमिटेड दिस रिट पिटीशन एंड इशू ए नोटिस टू द डिपार्टमेंट। एंड इन दिस केस बिफोर द ऑनरेबल कोर्ट दिल्ली हाई कोर्ट इसमें जो रिट पिटीशन फाइल की गई थी वो दैट वाज आल्सो रिलेटेड टू सेक्शन 148 ऑफ द इनकम टैक्स एक्ट 1961। इसमें लंडन काउंसिल फॉर द पिटीशनर स्टेट दैट impugned notice are invalid in the eyes of the law and void from inspection as they were issued without following the process of issuing of prior notice under section 148A of the Act. He further submitted that the impugned notice are invalid as they have been issued under the pre-amended provision of the Act, which were no longer in force on the date of the impugned notice, because new Finance Act has been amended and taken effect with effect from 1st April 2021. Therefore, the notice issued after 31st March 2021 in relation to the previous provision of section 148 are not valid. Then they said the amendment that has been applicable in respect of the notice which will be issued under section 148 after with effect from 1st April 2021. And they have also said in this petition the Bombay High Court as well as the London proceeded of the division bench of this court in the case of Mohan Kohli versus Assistant Commissioner of Income Tax के अंदर इशू को लिया and is subsequently following the interim order passed by the London division bench in case of Mohan Kohli versus Assistant Commissioner of Income Tax dated 7th July 2021 as well as similar interim order passed by the Bombay High Court. The Honorable this court, there shall be a stay of the operation of the impugned notice dated 9th June 2021, 30th June 2021 and 28th June 2020. This order was passed and next date of hearing has been fixed for 28th September 2021. अब इसकी तो ब्रीफली हिस्ट्री हम लेते हैं। ये जो the taxation and other laws, the relaxation and amendment of certain provision Act 2020 था, which we referred as a relaxation act. This was passed by the Parliament for extension of various time limits due to COVID. But question rises whether it has extended the power to substitute any provision of the enacted bill, whether the proceedings are to be carried out as per the old provisions or the new substituted provisions. अब इशू इस केस के अंदर ये है कि whether two parallel reassessment proceedings under the same statute can be used for the same purpose for initiating a proceeding of reopening of the assessment during the period from 1st April 2021 to 30th June 2021. The limitation where they have extended. The sequence I have to see on 29 September 2020, the Relaxation Act was passed by the Parliament, which provided for extension of various time limit for completion or compliance of action under the specified act. And Income Tax Act is also come under this specified act. On 27th February 2021, the CBDT issued a notification SO 966E, as per which the time limit for completion of the action included the reassessment proceeding was due to expire on 31st March 2021 was extended up to 30th April 2021. This was done by the government as per the power conferred to it under Section 3, Subsection 1 of the Relaxation Act. Further देखिए, on 31st March 2021, the CBD issued notification number SO 1432, and this notification clarified that the reassessment orders, which was earlier to be passed on 31st March 2021, can now be passed to 30th April 2021. Further, that the notice under Section 148 of the Act, which were to be issued on or before 31st March 2021, can now be issued on or before 30th April 2021. It was made clear that the reassessment mechanism as per the old system, which was prevailed before 31st March 2021, shall be applicable. This was done by the government as per the power conferred in subsection 1 of section 3 of the Relaxation Act. On 27th April 2021, the CBDA issued notification SO 1703, which clarified that the reassessment orders, which were earlier to be passed on 30th April 2021, can now be passed up to 30th June 2021. Further, that the notice under Section 148 of the Act, which were to be issued on or before 30th April 2021, can now be issued on or before 30th June 2021. Further, that the notice further stated that the reassessment mechanism as per the old system, which was prevalent before 31st March 2021, shall be applicable. This was again done by the government by virtue of the power under subsection 1 of section 3 of the Relaxation Act. Our Relaxation Act is section 3 or subsection 1 क्या कहते हैं? Relaxation of certain provision of specified act. Section 3 subsection 1, where any time limit has been specified in or prescribed or notified under the specified act, which falls during the period from 20th day of March 2020 to 31st day of December 2020, or such other date after 31st day of December 2020 as the central government may by notification specify in this behalf for the completion or compliance of this action as completion of any proceeding or passing of any order or issue of any notice, intimation, notification, sanction, approval, or such other action by whatever name called by any authority, commission, or tribunal by whatever name called under the provision of the specified act or clause B, filing of any appeal, reply or application or functioning of any report, document, return or statement or such other record by whatever name called under the provision of the specified act. Obviously, the government has the power to extend the time as per the Relaxation Act. The situation is entirely different in the present case where the specific provision has been passed and Finance Act 2021 has been passed by the Parliament. So it cannot be said that the Relaxation Act gives power to the government to temporarily suspend the provision of the some sections pertaining to the reassessment. And when the finance bill has been got the assent of the president, whether this relaxation power given to the government under Section 3 can supersede the provision of the Statutory Amendment Act of the Finance Act 2021. अब टाइम जोन क्या है? अब इसके अंदर आप सिनेरियो देखें कि नोटिस इशूड between 1st April 2021 to 30th June 2021 and notice issued after July 1st to 2021. Activity देखिए, prior assessment year for which notice can be issued up to 31st March 2021 was the assessment year 2013 to 14, 2013-14 and subsequent assessment year 17-18 तक इशू होते हैं. A validity of the notice issued जो 31 मार्च 2021 तक इशू हो गया है असेसमेंट ईयर 13-14 ऑनवर्ड्स वो वैलिड है. अब जो नोटिस 1/4/2021 से लेकर 30 जून 2021 के अंदर इशू हुए हैं फॉर द असेसमेंट ईयर 2013-14 जो 17-18 वो डिस्प्यूटेड है. अब जो नोटिस 1 जुलाई 2021 को इशू हुए हैं असेसमेंट ईयर 11-12 एंड सब्सिक्वेंट ईयर्स और एप्लीकेबल असेसमेंट रजीम क्या है 31 मार्च 2021 तक पुराना रजीम है और 1/4/21 से 30 जून 21 तक में डिस्प्यूटेड है और 1 जुलाई 2021 के बाद न्यू रजीम है. Now, there was another case of the Bombay High Court in the case of Ramanda DI Private Limited versus DCIT, writ petition 11766 of 2021 dated 3 June 2021. उसने बॉम्बे हाई कोर्ट ने भी proceeding has stayed the proceeding of reassessment on account of non-compliance of the new procedure laid down under Section 148A. तो my dear learned friends, ये issue of notice under Section 148 has come in dispute due to the amendment in the Finance Act 2021. Of government may due to COVID, limitation period has been extended, but Honorable Bombay High Court and Honorable Delhi High Court has stayed the proceedings and operation of the notice issue under Section 148 under the old regime after 31st March 2021. Thank you very much.